In March of 2014, an apartment fire in Brooklyn, New York spurred a series of events that led to the arrest, interrogation, and prosecution of Thaddeus Boone, who was pending trial and awaiting a potential life sentence. In part one of this series, we discussed the facts of the case and got introduced to our panel of guests, including Adam Heyman, Anna Carlsen, Sarah Siegel, and Professor Maria Hartwig. On this episode, we're going to explore the trial itself, learn about the strategy of the defense team, and understand the emotional roller coaster that they all experienced. We'll also hear some new facts of the case and how important credibility of the evidence was to the jury. Thanks for listening to part 2 of this series of Truth Be Told. This is the Truth Be Told podcast, where we unlock the secrets of strategic communication. We finished off part 1 of this series with attorney Anna Carlsen discussing some new facts she learned about what occurred during the interrogation of her client. Anna's going to bring us back to when she first found out that investigators used what's known as the false evidence ploy on Thaddeus during his interrogation. He had continued to insist on getting a smoke test done on his clothes, and it wasn't until the hearing that his team really knew what he was talking about.
Early on when we first met Thaddeus, he had this running theme of, I want you to do a smoke test on my clothes. And we would just look at each other every time and be like, dude, there's no such thing as a smoke test. We don't know what you're talking about. And he would say, no, the fire marshals did it. They did a smoke test on me. He said, we really don't know. And we really don't know what you're talking about. There's no such thing as a smoke test. But he wanted us to get his clothing out of the evidence. He wanted us to test it. You know, we just didn't really know what he was talking about. Comes to the hearing, the fire marshal gets on the stand. He's describing what are some of the things that they're doing in the course of the interrogation, and he was really proud to tell us about a false evidence ploy. He said, this was the idea of one of the homicide detectives, and I thought it was so clever. I'd never seen anything like it done before. What we did was we broke open a DNA testing kit, which has a long Q-tip, and we basically told him that if you swab behind your ears, we'll be able to get smoke DNA from behind your ears. People forget to wash behind their ears. If they were in a fire, long time before, we're still going to be able to grab that smoke DNA from behind the ear. So we swabbed behind his ear. We went out in the hallway. And then, of course, we just colored in the tip with a highlighter. But we came back in the room. We told him, look, you were positive for the smoke DNA. We know that you were present at that fire because, look, the scientific test showed that you were there. And we had no idea this was coming. There was obviously no documentation of a
from God.
Smoke DNA test, a fake test. Nothing like this is anywhere in the fire marshal's notes. Nothing about this is anywhere in the detective's notes. Obviously, it's not a video.
Not. Obviously.
Yeah. We had no idea it was coming, and I just remember feeling the floor drop out from me in the courtroom and thinking, oh my God, the person sitting next to me, he really got completely overwhelmed.
And still believed it to that day, it sounded like, right? Still believe that was an accurate test at that time.
Yes.
Yeah.
Yes. CSI, are you listening? You are hurting people.
Right.
Yes.
Right.
He thought there had been some kind of scientific error, but in that moment, he was totally convinced that they had incontrovertible proof.
I mean, Dave, you talked.
And there was, that it must have been some kind of mistake, but that he then had to do something to go along to explain the mistake, to make it all whole.
I'm going to give just Thaddeus's words directly from that, and this is back to the directive him. And so what you're speaking to, you asked him, so at some point did the fire marshal stop accusing you and leave the room? And he said, no, they told me they're going to do a test. They said, we're going to do a soot test on you, and if the soot test comes back and you got soot behind your ears, we know that you were in the fire. I said, all right, take the test. And then, as you said, he describes the Q-tip and came back, and it sounded like that was the beginning of, we know without a doubt it was you.
I think, Thaddeus' description from the beginning is they come in and they just start hammering him, and it's not anything like what, like they testified to. I mean, we were so lucky to have so many state actors be dishonest about what happened and just not be honest about things. You know, you talked about everybody being human. Everybody is a human being. There was a lot of pressure on these people that night. They had 4 children and a grandmother in multiple hospitals throughout the city. Press was on the scene at the time that they were putting out the fire. They brought in a homicide detective to help in the interrogation. They had fire marshals coming in. They needed a confession because they knew that all of their evidence was circumstantial at best.
Right.
And despite the soot test, he didn't crack just then. It took more and more time, but like it was just as we say in the law, it was the totality of the circumstances that really just created the perfect narrative for us to attack a oral, a handwritten, and a 45-minute videotape confession.
Yeah.
It may be legal for them to have used this test, but the investigators of this case clearly did not want to admit that they had used this test in front of the jury.
That's interesting.
And so
they knew...
although it came out from this junior fire marshal in the hearing, everybody denied it at trial.
All the police said, while the fire marshals were in there doing this and doing all this, we had no idea that they were doing it. I just heard very recently that there was a false evidence fly.
Yes, police on the stand in the trial completely denied any involvement in this, and the fire marshal said it was the police's idea.
No one wanted to take
we wouldn't have
ownership.
come up with this. So the jury could sense that there was something about, not sense, the jury could see and hear with all of their senses that there was something about this interrogation that was making even the officers uncomfortable.
The false evidence ploy, or lying about evidence, is something the U.S. Supreme Court has permitted in the landmark case of Frazier versus Cutt. However, there's been legislative movement across the U.S. to remove the use of this tactic, as it's known to be a likely contributor to false or unreliable confessions. Let's learn more about that from our panel here. The whole reason to use the false evidence ploy is you don't have the evidence in the first place. Otherwise, you wouldn't have to lie about it. And if you don't have the evidence, that means it's circumstantial at best, which means you're using that ploy and the tactic as a test to see how is somebody going to respond to this. And based off what you talked about earlier, that's not going to help us at all.
Yeah, I think you're making a great point that I want to elaborate on. I think that one of the reasons that law enforcement use this is to provoke a reaction somehow. And that's just poor training, to not be able to generate questions or elicit an account from the person without resorting to just bald-faced lies. Again, it's poor training. Here, my disdain for the tool analogy comes into the picture, because these legislative efforts and that you've been involved in, Dave, to ban the police from lying to juveniles. One of the complaints that is often heard is, well, it's just one of our tools and it's a valuable tool, and so don't take it away. But that metaphor is entirely faulty, because a tool is designed to have some kind of intended effect. And Mark Fallon, who you also know, has this great analogy which I think should resonate with law enforcement, that if turns out that the department has issued guns that fire haphazardly, we wouldn't consider that to be just another tool that might help. We know that it's a risk and a danger. And the same applies here. So it's not a tool. What investigators should obviously focus on instead is investigating in order to uncover evidence.
I think in this case, the police and the detectives who had been responsible for suggesting this false evidence ploy in the first instance didn't want to talk about it. But as you've seen, and maybe your listeners know, some police officers love to get on the stand and say, oh, I'm allowed to lie. That's A-okay.
Right.
You know, I'm doing it right. And they like to do that for the same reason that any of us like to say that we're doing something right. It's because, you know, we want to believe in the same just world that somebody in the interrogation room wants to believe in. When we as jurors or people in a courtroom who may not be experienced with the particular facts of this case, when we're there, we want to think like, oh, well, the people who are presenting evidence to me, these witnesses, these lawyers, this judge, they know what they're doing. They really know what's true and what's false. They have hearings about this, about what's appropriate to present to me, the juror, and then they have instructions about how I should treat this evidence or not. Like, we know what we're doing in these cases. And a lot of the rules that we have are just wrong to get to that result. They're boomerangs that are hitting us all in the face. You know, you could talk about this false evidence ploy stuff, which is horrible and produces horrible injustice in the world. And you can also talk about things kind of down the line. So there's just an example. There's a legal rule that says we are going to allow, at least in the state of New York, we're going to allow medical records to come in and all of the hearsay contained in those medical records, like what you told your doctor, not in court, and maybe even though you're not in the courtroom itself to like say that this was true and you said it, we're going to allow all of that information to come in because what you tell your doctor must be true, right? Like, come on.
Right.
When did you last tell your doctor the whole truth? When did
How
you
much
have
you
time?
drink every day.
Right.
Yeah, I know.
How much do you use substances, and when did your doctor
flossing.
last have time to like elicit or listen to the full story from you? But that's a legal rule, and we know now that it's a terrible rule, but it still keeps happening. And so there's structures, both within the interrogation room and in the courtrooms across the country, that are supposed to deal with these questions of truth and falsehood that are just not set up to do their jobs.
Yeah, that's a really good point. I had written down as you were talking, when investigators or detectives get on the stand, I want to talk about it. It's because, and I hear this the same in the legislative argument, we use this tactic because it works. And it's defining what does works mean, right?
Yeah.
And so we know
Yes.
works means it's going to elicit a response, but that might not be the appropriate response or a truthful response. And then you get this outcome kind of bias of, well, it worked. In this case, we were able to prove this person was guilty, and I got there by the false evidence ploy, so it must work every single time.
As Sarah explained, one of the issues with tactics like the false evidence ploy is that judges and juries may not understand the full impact of such a tactic. So I wanted to ask our team, what role does the court actually play in reviewing the voluntariness or reliability of a confession?
So the place where I am only practiced, I only am licensed to practice law in the state of New York. So let me say that. And different states have different rules. Most cases that are criminal, and most criminal cases happen at the state level, not the federal level. Most prosecutions happen in the states, and rules vary wildly from state to state, both in terms of what the legislature has passed and then what judges have said in the absence of a legislature having passed a specific rule about a given problem. And the rules of evidence, which we're talking about here, mostly are judge-made law.
Right.
Until a legislature has the time and the attention and the will to do something else and say, oh, this is really wrong. You have to do something different. So in the state of New York, a judge is supposed to figure out at a hearing whether something was voluntary or involuntary, whether a confession was voluntary or involuntary. And in doing that, they're supposed to apply this test called the totality of the circumstances. And the prosecution is supposed to bear the burden of proving beyond a reasonable doubt in the hearing that the confession was voluntary, or the statement that they wish to use at trial was voluntary. What does that mean? What does the totality of circumstances mean? Who knows?
Right.
Nobody knows. I mean, that's facetious. There are plenty of cases that will call one thing or another voluntary or involuntary, but all of those decisions that are made by judges are infected by the same kinds of biases and errors and factual rules of thumb that turn out to be false rules of thumb as everything else that we're talking about. You know, I have great respect for judges and the extraordinary work that they do and the seriousness with which they take their tasks. But it turns out that none of us was there. It turns out that none of us are really, really good at figuring out what is true and what is false in the testimony that is presented to us without a lot of additional context, a lot of investigation into what is actually knowable without somebody just telling you. What is on video? What forensic evidence really is there? Do multiple people without motives to lie tell the same story about this? Would they have had the opportunity to see? These basic kinds of questions are really important, and they tend not to be answerable in a lot of these voluntariness questions because you're trying to look into somebody's head and see, was this you? Like, was this really your choice? And so you have different judges trying to apply the same standard and really just not applying the same standard at all.
I mean, in our case, they let the statement in.
They
we,
did.
We,
Yeah.
we had a whole hearing litigating judge. This was not a voluntary statement.
Right.
The duration, the no food, the no calls, the false evidence ploys, and a judge said, I think there's enough beyond a reasonable doubt that this is voluntary. I'm the fact finder here. I'm going to move it along to a jury and let a jury decide.
Did you use expert testimony for the suppression hearing or only for trial?
We debated whether to do that. We didn't
want to, I think, put...
We could have.
We absolutely could have. We didn't. We just wanted to keep her for the trial because we knew that the judge we were in front of was likely not going to suppress the statement just based on hearing from cops, and we thought it was risky to do more. We could have put Thaddeus on.
Right.
We could have had the whole entire trial in front of this judge before a jury, and we could have gotten the whole statement tossed. We could have, but it would have been risky because I sometimes have faith and I sometimes don't have faith, and I'm not sure that the judge, having heard from Thaddeus and Maria at the suppression hearing, would have said, I'm tossing this statement.
I think he still would have said, I think it's appropriate for a jury.
Yeah.
Yeah.
Not for one person.
It's a huge thing to say that this case is not going to go to trial.
Right.
Which would have been the import of
If you
of
had
that
tossed
kind
the
of
statement,
decision.
there was nothing left.
Yeah.
You had some really... I mean, you did have some circumstantial evidence, but they would have had to dismiss it. I don't think this judge wanted
That
to
puts
do
a
that.
judge in a very difficult
Very
spot.
difficult.
Right.
Yeah, and there's an important piece that's particular to New York State. This is not true in some other places, which is that there is an absolute New York State constitutional right to present the question of voluntariness of a confession to the jury, even if a judge has already opined on it, in a decision to the lawyers. It's ultimately up to the jury because it's a factual question. And in the United States,
And we were
we're supposed
limited,
to trust juries for
and that
facts.
judge limited us to not allow Maria to talk about the voluntariness, even though we are allowed to argue to a jury. There's an entire jury instruction on the voluntariness of the statement itself.
In a review of Thaddeus's interrogation, the team found several other factors that align with Professor Hartwig's testimony as contributors to false or unreliable confessions. Two of the concepts discussed include the tactics of maximization and minimization, often used in conjunction with each other. Sarah highlights how these issues were prevalent even before the interrogation started.
I mean, I think the maximization probably started when Thaddeus was pushed, when his face hit the sidewalk. You know, like the police who were supposed to be investigating this case thought that he was guilty and thought that he was guilty of something bad enough to cause him physical harm. I think that just continues throughout where investigators who are, from the NYPD and from the fire department all just keep telling him that he's guilty and he's not telling them the truth. And that this is very serious and that, he's going to be charged with murder, making an already terrible situation seem much worse so that they think like, oh, if he feels bad enough about what we assume he did, then he must crack. That must be the moment where we break through, because again, it's their goal, is their assumption that the breakthrough to an admission is a breakthrough to truth when it's just not the case. This is the issue. But there's also minimization, saying like, oh, we're your friend, we can help you, that kind of classic stuff.
So what to the research piece, because we see this all the time in these false confession cases, is there's the very practical, simple example. If, it's a homicide, it's, well, you must be a terrible person, you're a cold-blooded murderer, or listen, it was just a mistake, it wasn't that big of a deal. And it really leaves the interviewee with one choice. But what does the research tell us about that? And do we see that often in false confession cases?
Yes, especially minimization techniques. Essentially, it's affecting people's decision making because it's systematically playing up the penalties associated with continued denial, and minimization then provides a kind of pathway, a rationalization. They are used in tandem, indeed. I think there's what people should understand is that we use this term crack, but that implies that the confession just sort of erupts, like the person just decides, okay, I'm going to confess, and here it is. I think it's far more frequent that it's a series of concessions that are false.
It's gradual.
Yeah, and making these small concessions that, okay, admitting to something to appease the interrogator then opens the door to, first of all, they can then accuse you of having lied to them or withheld information. But I just want to sort of red flag that term a bit, like that a person cracks. It's an elongated process of these types of tactics that are meant to convey to the person that denial is pointless and it's not in their best interest. So if you think about the whole process through the lens of social influence and persuasion, then it might make a lot more sense. If you ask people, have you ever bought something that you didn't really want because the salesperson was pushy or somehow convinced you? I think most people would say yes. And that's essentially what's happening in these cases, that the whole process is designed to make an admission seem like the most rational thing for the person to give. And it's also very important to understand that for most innocent suspects, this is viewed as a short-term choice to terminate the pressure of what's going on, and not as the nail in their own coffin, which it at times is. So again, it's game, a confidence game really, that is manipulating people's perception of the consequences and the benefits and the penalties associated with denying versus admitting.
So in this case, they upped the pressure throughout the course of the interrogation of Thaddeus. One of the ways that they did that was, going into this, homicide detectives were involved because two of these children were, in fact, and we heard it over and over again in trial, seconds from death. If they had been inside of this fire for very much longer, they would have died, and they were hospitalized for a significant period of time with burns on the insides of their lungs from inhalation injuries. So homicide detectives were involved because they suspected these children would die. The interrogation began with trying this tactic of, we need you to help these children. Trying to make this emotional appeal of, we can save them if you just tell us where the fire was, how close they were to it, whether you used an accelerant, something to start the fire, like trying to get him to save the children by providing information. And when that had no effect, they upped the stakes falsely. They increased the pressure by saying that the children had died. They never admitted to that, I think, in the trial. But Thaddeus, that was something that was really crystallized for Thaddeus. He insisted, they told me the children had died. I would be charged with murder. I would be charged with multiple murders. And they said to me, no, everybody will sort of understand if this was, if you had a really good reason, or if you were really, everybody will sort of understand better that you weren't intending to kill anybody, you were just trying to make a statement. And I think for Thaddeus, it started to become, well, I'm not just going to let myself be charged with multiple murders. I have to provide some explanation.
That kind of goes back to when I accused you all of being coercive as attorneys, but it's the same as like a plea deal type conversation, right? Because he's weighing these two options.
He's trying to make a rational choice.
Right.
Yeah.
One of the difficult issues in false confession cases is being able to recreate the context for the judge or the jury as to what the interviewee was feeling or experiencing during the interrogation itself. I asked the team how they strategize having the jury see the interrogation through the lens of Thaddeus himself.
How do you put a juror in the position of Thaddeus, right? That's what you're trying to do, is we can sit here and talk about the science and all these different things, but unless somebody's sitting there feeling like they can't leave the room, they're being told evidence exists that he believes to be true, and that's important, right? We can talk about it now, and it's like, well, that's silly. There's no soot test. But in the moment, he clearly thinks that's true. He thinks that kids have died, and he's thinking the only way to get out of this room is to say, fine, I did whatever. How do you put a jury in that mindset?
I mean, look, we didn't talk about this, but he hadn't slept the entire night. He was also under the influence of alcohol and marijuana when he got tackled by the police. And
He was worried about his mom who had an aneurysm and was in the
and
hospital.
So these human things, I think you really have to have jurors understand. But, one way was pre-selecting the right jurors during jury selection to talk about, well, what reasons do you think someone would do that? So that kind of gives them some sort of idea. But I think your question is, how do you tell someone's story is what makes us sort of honored to do this kind of work, is that we're gifted with this opportunity to tell his world without even having gone through it. And we go to criminal defense trainings where they teach us to be really empathic and get to know ourselves and understand emotions of ourselves and our clients and everything in between. And it's important to have an emotional aspect to what you do in this work. It's not just all knowing the fire science and knowing the confession stuff. You also got to be a human being too, and be able to stand in front of people and connect with them
and communicate it. Yeah.
And this was a case where Thaddeus testified. I mean, he put them in the room.
Yeah.
It's not the
Wasn't
norm
hard.
in a criminal defense case.
Powerful. It was reading through
Right.
his testimony. It was powerful, and I've got a bunch of that highlighted that I wanted to bring in.
And
'cause
you
it's-
know, and talk about like risks with putting people on. You can't control cross-examination,
right.
and you can't even control direct. And so you have to find a nice balance between spending too much time and having people just, sound scripted and just be all over the place and being natural. But like, there was a lot of stuff to talk about, and we had to make sure we had a lot of time with him.
We also did we did a lot to try to investigate and corroborate as much as we could in concrete detail about how this could have happened. So, we went to the precinct and we made sure that the jurors would know what that interrogation room looked like and who was, which detectives would or should have seen whatever was happening.
We
in
had
the
an
place.
investigator testify. We
Yeah,
had an
we had-
investigator
we had Tom-
measure
yeah, Tom
the interrogation room.
Yeah, and so he could just things like that.
Yeah, and from Anna's really exceptional opening to the closings in the case, we were able to show the jury consistently what had happened and in a detail that the police just were unwilling to offer because they were uncomfortable with what they had done. We also were helped out in this instance by firefighters and fire marshals offering testimony that just had not been tailored.
Yeah, the
to the way that-
juxtaposition was really striking. We talked a lot about this today, but
Yeah.
had witnesses for the state been a little more honest about what happened, their version of events was so different than what Thaddeus's was that it was hard not to just question a lot of what they
Doubt
had to
everywhere.
say.
Right.
And, I'm not in the business of giving law enforcement advice about how to testify or not testify, but I know a lot
Now's
of
a
people.
good time to do it. They're listening.
Just be
Yeah.
honest.
Right.
You can admit to mistakes. It makes you more credible to be like, yeah, I was yelling at him. And I was under a lot of stress and all that kind of stuff. But when you say everything was just roses and we were holding hands and it was just wonderful and it was kumbaya.
Yeah, we weren't under any pressure to solve the case. I
No,
mean, just,
Right.
it was so unbelievable that like if I could give one piece of advice for anybody who's testifying in anything, the more truthful you can be, the better, because otherwise sometimes, even though we're saying it's hard to tell when someone's telling the truth or not, sometimes you can tell.
Simple but impactful feedback from Adam. The credibility of testimony from witnesses, even experts, can drastically impact how a jury receives that evidence when deliberating. Our discussion continues to break down Thaddeus' confession as we bring up the issue of the contamination error. After all, how could an innocent person have so much knowledge about the crime if they weren't responsible for it?
The last piece of the confession I want to get into is contamination and some of the details provided. But before
Another
that,
fire marshal assist.
and they helped you. It was another surprise that you got.
Yeah, they testified in the course of the trial that they had told Thaddeus various details that the police later seized on as something that only a perpetrator could have known.
Okay.
And there's nothing unique in the statement either, which was also striking as well. Just details that he was sharing that wasn't already known by the authorities.
So when you get to, before somebody gives the kind of the full statement, and you put this well, Maria, is like it's usually a little bit at a time, right? It's not like all of a sudden somebody flips a switch and here's everything they did. But when you look at the types of false confessions that the research generally categorizes, right, is you've got voluntary, where somebody just comes forward because they want credit for something, notoriety. You have a coerced internalized, which is where somebody actually believes to think that they may have actually committed the crime. And then you have coerced compliant, which I feel like, that's what I want to ask your opinion on. This would fall more into that category where you said he recanted right away. And it's this concept of I have to comply with the investigators because they're not believing my denial. They're telling me they have this evidence anyway, so that it's going to look guilty in front of a judge or jury. What other options do I have? Would you agree that's kind of where this falls in that bucket?
And also, like, the truth will set me free ultimately. And this is such a horrible, horrible moment right now that I'll say whatever I have to say to end it.
Right.
And know that ultimately down the line, I will be freed, right?
The contamination piece at the end, and this is the part that I think is really difficult, is when a jury, a judge, the news sees, like, here's the confession, and he, she, whatever the case was, let us know where the murder weapon was, told us they stabbed the victim 3 times, they started the fire here, and people are like, well, of course it was that person, because who else would have known that other than that person? And that's this kind of third error that we see in false confessions, and it's known as contamination, which I know you spoke to in some of the testimony. And as just going through some of the direct of Thaddeus, I'm just going to give you a couple quick examples, and you can walk me through the context here. He talks about in his quote confession or his statements about a jacket, right? As I think was one of the alleged sources.
Yeah, a leather jacket in the room that he allegedly lit up.
So you had asked the question, where'd the idea of the jacket come from? And in his testimony, he says, the reason I said the jacket is because we just went shopping. I just remembered that she had a jacket, so I said jacket. And so that's an example of just kind of trying to guess, right? Trying to fill in the blanks. But you have things where he literally just repeats, like you're talking about the dresser and all these different facts where he says himself, Thaddeus says, well, I said that because they suggested it, or I said it because I heard this during the interrogation, so it seemed to make sense. And there's something about the keys as well, like whether he had her keys or not. Can you maybe give me kind of the example of what that looked like in his interrogation, of how, maybe not how many, but some examples of contamination that you saw?
Well, I don't know if this is really contamination, but it's clearly something that the jury was able to see in the final video. So when they're producing this confession, they are talking to him in the room in these many rounds. Then they have him write out a statement, and then they have him make a videotape. And I think all of these things were presented to him as, this is the next step, this is the next step to get to, to get you to a judge, we have to do these things. So I know that the last piece of evidence the jury asked for before they rendered their verdict, they asked to watch the video again. And the video is really clear that he doesn't remember the order of events. It's very clear from the way the investigators have to lead him from point to point that he doesn't seem in this video to have an independent recollection of, I went here, I went here, I went to point C, I set a fire, I did a thing. The theory of the case was that he had set a fire in a room, set a fire in a hallway, and then walked to the kitchen and turned on a stove burner. This was a very eerie detail. When police officers came crawling through the smoke, they clearly testified that they saw one of the burners on the stove was lit. They could see the blue glow. And so Thaddeus needed to make a statement accounting for the stove burner and multiple points of origin. And in the videotaped confession, he just kept skipping things, and they kept redirecting him back to, oh no, you forgot, let's go back a minute. What about the hallway? It was very clear that they had an order of operations that they were walking him through, and he was just not getting there independently.
And specifically, it was the prosecutor who was in the room. It wasn't just the cops anymore. They brought a prosecutor down to do it, so he was totally prompting him on a lot of things. I'm
breaking in here just to say that it's very clear once you've watched the video multiple times. And when you asked how did we put people in Thaddeus's position at the time, one of the most important decisions that Adam and Anna made in the trial was that we would show that video as often as possible, because the first time that you see it, it's horrible. It's horrible to watch. And that's one of the, Anna, I think that you said when you first got this case and first saw this video, you thought, I don't know.
It's pretty bad.
It's a bad set of facts.
It's bad. But you really have to look at it deeply. And once you've looked at it multiple times, you're like, oh, this makes no sense at all.
How much was not recorded?
So
hours and hours.
15 hours and 15 minutes was not.
Yeah.
Everything. And so another thing that was just kind of striking was They say they initially get an oral confession around 6-7 hours in, and then he gives a written confession. And the detectives, again, just should have been honest and said, I was in the room with him when he was writing down everything, and we kind of told him what to do, because there were 2 pieces of paper that were his actual handwritten confession, but they were very formal. And they looked like a police officer would have said, hey, put your name up in the left-hand corner, put the date here, end it with an apology, all these kind of things. And instead the cops said, during all of their testimony, we gave him a blank piece of paper and we left the room.
Yeah, this was all completely spontaneous that he made this very
and so I'm like,
formal
when
looking
he writes up
document.
in the left-hand corner and then he says like 2:12 a.m. and then he signed, this is just him doing this on his own? And the police officer was just like, yeah, it was just him. It's like, you could have just said I was in the room with him. You know, like there were so many opportunities for us to just exploit that, like, they're not telling the truth.
Yeah.
And just to circle back to the more explicit version of contamination, the fire marshals, when they were doing their own rounds of interrogation later at trial, admitted that they had just told Thaddeus that that they saw a blue light.
Right.
On
How
the
do you
stove.
explain X? How do you explain Y? How do
Right.
you explain Z?
So now he knows
Why
it
would the
exists.
stove be on?
Right.
You know, they wouldn't be
Right.
just sleeping with the stove on. Somebody had to turn that stove on. So he was given all of the things that the fire marshals had found in their walkthrough in their interrogation.
And whether it was the detectives not doing the work to understand what had happened in the room when they weren't in the interrogation room when the fire marshals were in it, or the detectives straight up lying, it was a problem at trial that we were only able to solve because we had this particular kind of case and a particular kind of witness available to, you know, basically give the lie to what the detectives were saying.
So in some of the recent cases I've worked on, I've had to take all the details, all the assertions made by the interviewee. So every little detail, like it was the right burner and it was a pink jacket and I entered the house at this way at this time. And you look at every single detail that was asserted and then determine, first of all, was it even accurate? So if it was inaccurate, we can remove it. Was it even verifiable? So is there a way to even investigate it? If not, let's remove that. Then was it information that was either already in the news? If it was information that the investigators disclosed, so it was contaminated, let's remove that. And then what we have left is anything that was independently brought up by the interviewee that wasn't contaminated or anything like that. And even more stronger is if there was any information that the police didn't even know about that they were able to disclose.
Nothing of the last
that's what I was
two
gonna
existed
ask.
here.
So nothing in this case would have fallen those 2 last columns.
And the last one, there was nothing unique that he shared, nothing that the cops didn't know. Everything was the cops had told him. There was certain details not in the written one that were in the video, and vice versa. And so it was helpful for us to have that. And also, just like they had the ability to record all of this. They had the ability to do all of this, and they were so not willing to just say, yeah, we could have recorded it. Some said it was a police policy not to, and it was just a really shitty defense of what they did.
A lot of the discussions around false confessions would be really limited if it wasn't for the availability of recording and the transcription of interrogations. As more states move to mandated electronic recording, I think this is a huge win for everyone in the courtroom, especially if you're doing things the right way. I asked our panel of experts as to their opinion of recording interrogations.
On this side, what would have obviously been more helpful for a jury or for you all to have the full, transparency of the recording. Yeah. What do you see most often? Do you see recordings a lot? I know in New York State we've got some regulations around recording, but how often is that complied with?
I'm practicing in Washington now. I'm a public defender out there about to open my private practice in the new year. Heyman and Schuler, shout out. And they record basically. They try to record basically for the moment, but the recording isn't necessarily something that, like, there are a lot of things in a recording that are helpful to me. Like, even though they're catching the recording from the beginning, like, even though it's recorded, it doesn't necessarily make the interrogation any better. You would think that if you're being recorded, that, like, you'd be more mindful about some of the techniques that you're using or how you're doing it. But it just allows us to even show a jury even more, like, this is not the way to do it.
I think, and I had something to say to that too, but I think from my perspective of training, I think that will change as they're held accountable to it. Right? I think
in what way are you held accountable to it?
making confessions inadmissible, suppressing confessions. And like, to me, it's the same as, I'm a football guy, I'm a sports guy, so you could have thousands of cameras on the field that catch every single foul by a player, but if a ref doesn't throw a flag, it's not going to make a difference. And that, to me, is why, like, this legislation about using the false evidence ploy is so important, is if there's not some type of filter that's actually going to penalize those types of tactics or techniques, it doesn't matter. But I think about, like, the issue of Miranda is obviously a voluntariness issue and is argued all the time. If Miranda's advised properly and it's on video, if I'm a defense attorney, that's probably not helpful for your case. If I'm a detective doing it the right way, I want that on video, right? I want the transparency. I want the body cam footage of when I initially approached a subject. I think that'd be universally accepted if you're doing it right.
Here in 2024, the NYPD turns the cameras on when you enter the interrogation room. And almost every case that I have now, the entire interaction in the interrogation room is captured. And then interactions on the street are captured by body-worn camera. But there's still a huge black box. Yeah. And still, to this day, very often they'll turn on the cameras, they'll Mirandize on camera, you'll have a accurate Miranda warning, but then my client will immediately begin referring to a prior conversation. And I dozens of times my client will say, well, I already told that other cop the whole story, so why do we need to do all this? And then, then it's clear to a defense attorney that there was some kind of interrogation that happened not on this video. So we know that every conversation is still not being recorded when it should be.
Yeah, and the same with body-worn cameras, right? Because at least the ones that are used in New York City take time to turn on. That doesn't have any audio. You can sort of see an image but not hear what's happening. The officer physically has to turn on the body-worn camera in order to record a particular interaction, and you will just find constantly that they don't record every interaction that's relevant to a case.
I think accountability is tremendously important, but even if there was accountability, the only way we would see any substantial and meaningful change is by equipping law enforcement with the appropriate knowledge and techniques for how to question people. There's a whole different way of thinking about what the purpose of an interrogation is. I know many very skilled investigators who have no interest in getting a confession at all. If they get one voluntarily, they'll take it. But what they are particularly trying to elicit are false exculpatory statements. In some jurisdictions, they call these statements negative statements, but I think the appropriate legal term is false exculpatory statements. So these are statements where the suspect has been proven to have lied, often on multiple occasions about multiple different topics. And very interestingly, we often talk about confessions being the gold standard of evidence. To study a paper by my former PhD student, Laura Brimball, and her colleague, they show that when a jury sees a confession versus when they see a statement that is full of proven lies, they convict with at the same rate. So not only is it hazardous to try to press for a confession, there's also another way to impeach the credibility. I know it's kind of a court term, but to damage the credibility of people who are actually lying. And I think that the shift from confession-oriented interviews are pretty rapidly going to go through. I think we're going to pass the stage where, let's say in Europe, confession-oriented methods are not very common. Instead, the focus is on information gathering. And that's absolutely an incredibly important goal, to generate as much information as possible, but not all information is of equal value. And what I suspect will happen is that instead of embracing just generic information gathering, I think the law enforcement will gravitate towards these methods that systematically elicit statements from innocent suspects that are in line with the evidence, which explains the existence of evidence and makes it sort of not evidence anymore. And on the other side, showing guilty suspects to be deceptive repeatedly.
And the last thing for me for recording, I mean, there's things like it helps with investigators take notes right afterwards because our memory's terrible and all those kind of things. But, like Brendan Dassey's case is one that I've been passionate about and involved into a limited scope for a long time. We wouldn't even be talking about Brendan Dassey if that interrogation wasn't recorded. And so there's a lot of these cases that I don't think would have ever even seen post-conviction support if it wasn't on video. So just a lesson for all investigators out there. It's a win for everybody, I think, in the justice system.
And it protects the police from gratuitous and false accusations that they've been subjected to these coercive techniques.
Record early, record often.
Right.
Yeah. It also opens up leads that you may not know are important at all when you first receive them, right? Like I hope we'll be able to talk about this later, but the importance of the article that the judge was so exercised about that his son was in the New York Times also proved really important in our ability to investigate the case. And we were able to know those facts because they had been recorded.
The article that the team is referencing is titled Baptism by Fire. A New York firefighter confronts his first test, written by N.R. Sonny Kleinfeld of the New York Times. The journalist does an incredible job of compiling interviews, videos, and photos to tell the story of the heroes from FDNY who responded that night in March of 2014, which also appeared to help in the investigation.
We talked to the journalist who wrote it. We talked about his information gathering process. We called him up and said, we share your notes from the interviews with the firefighters so that we can get back to their original recollection of what they first saw when they entered the apartment. But one of the details that we thought was interesting about what the firefighters see at the moment that they come in low through the door or they crawl into the fire. So this was an apartment with a lot of people living in it. It was a very small 2-bedroom apartment with a lot of people living in it, an extended family, multiple generations of an extended family, and basically a grandmother taking care of all of the children of an absent mother. Mom did not live in the apartment. And one of the children lived in the living room. There was a teenage boy who slept on a mattress in the living room. And the prosecution's theory of the case was that everybody had been asleep when someone crept in and set these fires. And what the firefighters first saw when they entered was they entered the living room and did a sweep of the wall of the living room looking for people who might be unconscious in this.
They're on the ground.
Yeah, crawling on
the
the ground because of the smoke conditions inside the apartment.
There was almost no visibility except for seeing the blue glow of the flames and the orange glow of the flames along the ceiling. But they're just purely by touch. And the firefighter found the baby purely by touch. He felt the squishy diaper of the baby. That detail haunts me to this day.
Yeah. Having recognized the pack and play, right?
Yeah, he felt the pack and play. So as he was sweeping through the living room, very first moments that he entered, he found the mattress in the living room, but the mattress was leaning up against a wall. And so we hinged on that detail because we thought it would not make sense if you woke up to fire. And there was testimony. I mean, this teenage boy testified, and everybody testified about the living conditions, and they testified that during the day, when he wasn't sleeping, the mattress would be out of the way up against the wall. It didn't really make sense to us that he would have awakened in the night and in the smoke, in a panic, and put his mattress up against the wall.
Rather than get his siblings out.
Right.
Right.
Yeah.
So part of and who knows what happened in that, who knows what caused the fire, but our theory of the case is that this was an accidental fire, that this was a purely accidental fire that started somehow in the night, but that he had perhaps been awake and in the room when the fire started.
Somehow, because this is a 14-year-old teenager who gets on the witness stand and says, I was sleeping in the living room. We know for a fact he wasn't sleeping in the living room. Where the fire started in one of the bedrooms, it was our position he was in there. Not just that he was in there, but that he had completely lied to every single person, the grandma lied, that he wasn't smoking weed at the time, that he wasn't doing things. And we were able to find social media where he was smoking weed, and we confronted him with it on the witness stand. And to the lesson of be honest in the stand, he would no, that's not me smoking marijuana. You know, we really discredited him. And so we could argue somehow maybe he was smoking weed in the bedroom, he fell asleep, and something happened that started this fire.
I mean, there were so many areas of fire investigation that they just didn't pursue because they believed they saw 2 points of origin. They didn't preserve electrical wires. There was an extension cord with a million things plugged into it. They didn't preserve that. They didn't sort of look into it further, whether it could have been an electrical fire.
And that cord was on top of a dresser that's sort of almost adjacent to the bed in this bedroom where normally this teenage boy's older sister would have been, but she was out for the night, which is why anybody really would have preferred to sleep in an empty bedroom rather than on a mattress in the middle of the living room, perhaps be able to smoke things you're not able to smoke when you're just in the living room and your grandmother's nearby, perhaps be able to play video games on an overloaded extension cord.
All this information would have been available to investigators the same way it was available to you?
Yeah, I mean, it was all, this was part of their investigation into the fire. They photographed the cords. They photographed every inch of the bedroom. They photographed all the electrical equipment.
And they could have been more, but they could have been more like in the ambulance, the teenager told an EMT, I think this was a setup. Like he was saying these wild things. They could have pushed other sources of suspects.
But they had a confession.
But they had a guy that they thought did it, and they could have gone on to the teenager's social media. It wasn't hard to find it, and they could have been like, "Hey, were you smoking that night?" But nothing. Just all fingers just could come to Thaddeus.
There was this eerie detail that we talked about a little bit earlier, the blue glow of the stove burner. Right. Photographed on top of the stove were multiple sticks of incense. And I think they questioned Thaddeus about this. They asked him, were you lighting incense? And it was a no from him. But part of the theory there also was somebody in the apartment trying to cover up a smell? Trying to cover up the smell of
maybe
marijuana.
The teenager who was smoking
Does
marijuana.
That explain? Because if you have an arsonist creeping through the house, trying to then, activate the gas and blow everyone to kingdom come, what's with the little pieces of incense? Where do those fit into the theory of setting this fire? Doesn't it make more sense that somebody was perhaps in the middle of doing something with the stove burner and an accidental fire starts?
Right.
They tried to take DNA from the stove knobs, but the heat of the fire destroyed any DNA.
As we sat on the panel and discussed the research behind false confessions, the strategy of trial preparation, and the logistics of courtroom procedures, it's easy to lose sight of the human element that's at the core of the entire process. This team of attorneys truly cares about doing the right thing and representing their client, and I asked them what they felt like Thaddeus's experience was during the entire trial.
Maria testified after Thaddeus that we had a very strategic decision to make. Do we want Thaddeus to go first and then Maria, or do we want Maria and then Thaddeus? You could make a good argument either way, but we felt like having Thaddeus go first and then her coming in and talking about the general phenomenon was just a more powerful way to do it. We were able to also have Maria potentially explain some things depending upon what had happened during Thaddeus's direct, but I think he got it, sort of, I can't imagine what it must be like to be accused of a crime where you're looking at life in prison and every day you're coming to court. I mean, he was being woken up at like 3 o'clock in the morning from Rikers Island, having to come, he was barely eating. Like, I couldn't eat. I was so nervous, and so how much he took in of all of it, I think was, it's a hard thing to know, but when you're sitting in a trial, when your life is on the line, I'm hoping our clients are paying attention.
Yeah. I mean, I think he already knew all of this. He had lived this, and so he had lived this, gotten to a judge, and expected, they'll see through this right away because this confession obviously was false, which is why he expected to be released the first time he saw a judge, and then to just instead be detained, to be incarcerated for years before the point of a trial. I do think that there was something cathartic about hearing somebody finally say what he had been saying for several years on the stand, that it wasn't just him, but I think he already understood.
And I think we were also sharing work product with him because we wanted to show him how hard we were working for him because, look, we're appointed. And so there's this notion that because we're free lawyers, we're shitty, and there's a distrust sometimes that, we're just going to not work on your case and just plead you out. And I think oftentimes what builds a lot of trust is showing how hard you fight, not just in court, but like, look at this amazing motion that we have, or this affidavit from this expert and all that kind of stuff.
That's a good point. Talking about communication again, and maybe this case specifically or in general, how do you balance, you don't want to give false hope, obviously, to a client, but you want to keep them aware of what's the goings on are. How do you balance?
I mean, I was the bad cop all the time.
Okay.
This was a life sentence case. I mean, the charge of arson in the first degree, arson that causes, serious physical injury. He could have been sentenced to something with a maximum of a life sentence. And I just kept telling him that. And it wasn't until the hearing that I really said to him, I'm really sorry for how I've been going at this.
Yeah.
And, I don't want to say I have a lot of hope. I'm so skeptical of the whole judicial system, but I now fully believe you.
It's got to be so difficult because you want to be transparent, but you don't want to give false hope. And you may know something, or you feel a certain way of the judge that you get, or who opposing counsel is going to be. And I know that probably weighs into your mind. Are we going to win, lose, whatever? But trying to figure out how much you communicate to the.
Well, we had a really memorable conversation. Had we closed before Thanksgiving? Have we done closing arguments?
I don't remember.
I don't think we did. But we broke for the Thanksgiving break. And things were, I felt at that point in the trial, going really, really well for us. The jury was really locked in. They were really listening. We could feel that there was a good energy sort of between them. Like there was communication happening with the jury, and they were communicating to us. Sometimes you're on trial and the jury's refusing to look at you.
Right.
This was really, they were really.
To be clear, they were not communicating with us in words.
Yeah,
or
right.
No.
of any kind.
No, they were making eye contact. They were receptive. They were nodding along. By Thanksgiving, I told Thaddeus, "Look, you've eaten a lot of turkey sandwiches in jail on Thanksgiving. Next year, I don't think you will be."
Yeah, that's powerful.
It is a complicated.
He calls us every year on Thanksgiving.
It's really complicated to have to navigate with a client the decisions when you're dealing with such an immense amount of time. We can't quantify to Thaddeus what the odds are that he's going to win. There's so many rulings that happen that we don't know about. Things can go so many different ways. And when you're talking about these big decisions, I tell a lot of new lawyers who are coming into this, you're not just doing the legal stuff, but this is a human to human thing where you really connect with someone else and you're in a relationship.
Yeah.
You're in a real relationship where you got to work on it and it's going to be difficult at times. But if you're honest and you're pure in your intentions and you try to make it work, you hope that whoever you're representing trusts your judgment on things, because it's I often will tell clients, I'm like, when you go into the operating room, are you telling the doctor kind of whether you should do this procedure or that procedure?
Right.
We know a lot about this, but we also don't know a lot about how things can end up. And so we try to be risk averse, but we also respect the autonomy of the individual to make a decision about whether we plead guilty or not. And I got to say, were it not for his, pun intended, conviction and his innocence, none of us would be sitting here. We pushed him to say, don't die in prison. You can see your 2-year-old son when you're in your mid-40s, and that'll be way better. I promise you. I'm 46 years old. I'm like, I have a whole life ahead of me. Don't risk this.
Yeah.
And he just would not. He would not succumb to any more people telling him what to do.
Yeah, and that was extraordinary. And obviously, we're all sitting here because the right thing happened in this case. But that is not the only thing that could have happened, and it's not the only thing that has happened for my clients. It's not the only thing that has happened for people across the country who are facing similar choices, but with different risk aversions, different takes, and different, people influencing them in their personal lives. Just different factors at play where it is just not, I don't want anybody listening to this to think, well, if they don't take it to trial, they must be guilty, because that's just not true.
After all the hard work and the emotional roller coaster of a trial, it comes down to a jury of one's peers, deliberating on the evidence and weighing a decision that could impact the rest of your life. I asked the team about that experience, the emotions behind it, and how this case actually turned out for Thaddeus.
Man, we had a wonderful, the trial couldn't have gone any better than we could have imagined. It was excellent the way we tried it. Having read it recently, I just knock on wood that we got what we got and how we did it. And the jury, so he was convicted of a misdemeanor for taking her phone during that fight early in the day, which we were admitting to. There wasn't any kind of dispute about that. But on any felony, on any life sentence, the jury ended up coming back and they deliberated for...
They went overnight.
They went one night. I've had juries that stay out for 4 days. You know,
Right.
like this, they took their time and they came back and...
They watched the video.
They said,
Right.
we want to watch the
Multiple
video.
times.
And he's crying at the beginning of the video, and none of the cops would say, oh, yeah, he was crying or anything. He just looked like he had been beaten down. And
Oh yeah, I forgot about that. They denied that he was crying, but he was like on video
he's on
crying.
video just crying. And so they acquitted him of all of these life sentences and these other felonies. And, you know, it's a intense thing to sit there when the jury is coming in and...
We
waiting.
were all holding hands.
It was just brutal. And again, we're not the ones going through the life experience of this thing. We're
Right.
just doing our jobs, right? I can't imagine. I wouldn't be able to sit there and take a verdict if I was being. the
No,
one
I would
accused of
plead
it.
guilty.
I wouldn't be able to go through. It's just so intense, and you know, we have such a supportive community at Legal Aid, and everybody was there for so much of it and helping out. We had interns and other lawyers during jury selection doing like social media research at the time. Like we were trying to put as much as we could into this. Like this was a big case. And not all the cases that you try will there be these kind of big cases and there's press involved and there's 3 lawyers at the table. But we try to take every single one of these cases as seriously as possible because it was just like, honestly, it's one of the crowning achievements of my 20 years of criminal defense. It's to be
Absolutely.
a part of this team
Absolutely.
and to do what we did. I don't know if we'll hopefully have an experience like this again, but like with these facts, with how it went, like it was just a difficult case.
How's Thaddeus doing now?
He's doing well. He's a hard-working man at UPS. He's been out of trouble and just living his life. And
Sent me a
just,
picture when he got his uniform, and I again cried like a baby.
Yeah.
he calls us for holidays. You know, it's like we always promise our clients. You know, like hopefully when it comes back as a good verdict, we're like, hey, you got to call us and just remind us of like, you know, the gift of this thing, you know, and like because we impact not just kind of like the client themselves, but their families, and then they like the children. Like we had a case once where our client was accused of something pretty serious, and his partner was pregnant during the trial.
Yep.
And she was sitting there every day, and then we won the case, and he was freed, and like to see this kid grow up, and like it's just cool to like that your dad is here now. You know, so it was an honor.
As we know, hindsight's always 20/20, and it's easy to second guess somebody. But as the emotions and pressure of the investigation and trial subsided, I asked our panel what lessons they learned and what they hope that you, our listeners, could gain from their experience. After all, the entire premise of our show is to help you become a better communicator, whether you serve on a jury, as an investigator, or maybe you're ever questioned yourself.
What, for Maria, for you, what, for people that are listening or people that were sitting there listening to you testify, what some common takeaways you hope people learn from either your testimony or from the research in general?
That it doesn't have to be this way, that we have alternatives that we need to move towards. And it involves a professionalization of the practice of criminal investigation and curriculum that prepares investigators for the actual job of fact-finding. I want people to understand that this can happen to pretty much anyone. These are very normal behaviors to concede to this kind of pressure. And again, we don't have to accept this status quo. I think we are duty-bound to reject it and to... I think as a scientist, it's part of my duty to provide law enforcement with scientifically grounded tools, techniques, approaches that don't lead to these outcomes that can prove absolutely fatal. In this instance, it didn't, but there's another way.
Yeah. Anna talked earlier about the moment in the case that had chilled her the most. Mine actually came after the verdict, I mean, I was elated by the verdict. I was ecstatic with it. My heart was beating out of my chest waiting for it, and we celebrated. But I walked home and I saw a school bus pass in the other direction and just thought, how can I protect you? You know, if I don't have exactly this constellation of good luck that we had in this case, good luck and good work, but also a lot of good luck in this case, what can we do? And I mean, please listen to Maria, because we don't have to rely on luck. There are actual not tools, but techniques that we can use to get better information and not have people sit in jail for a long time waiting and hoping for a trial.
And at the time, there was no open file discovery. I practice in a new jurisdiction in Washington where we interview every witness beforehand. There are a lot of jurisdictions where, at the time, we weren't interviewing any of these people. There was no like sharing of information. Like the adversarial system really messes up the ability to figure out what really happened, you know? And so like we didn't have a police department ourselves. We weren't able to test anything. We weren't able to go in there in the beginning. Like all of these things,
He had gone in and knocked on the door. Adam would go
I
to
would
the
go.
apartment and knock on the door.
I lived nearby.
And hear that dog barking.
Okay.
Every time someone came anywhere near the door. Hear the dog losing its mind. But they did not want, understandably, I think, didn't want to speak to us. And didn't have to.
Fascinating, yeah.
Yeah, but it really is like, it's not a level playing field. And despite all the odds, Thaddeus held out. And despite all the odds, he got a team of lawyers and an organization that was really willing to put in the effort. I mean, this consumed us.
I'm sure.
There was
And
nothing.
he really wanted this story shared in this format.
Yes.
I was,
Yeah.
He gave
reluctant.
permission here, 100%. We're all reluctant to talk about
Right.
like
He was acquitted. His name doesn't have to be in the news again in connection
Right.
with this, but he really feels like,
he wants people to know he didn't do anything wrong, and his name is still out there.
Well, to
and he wants
further
people to
that-
understand why he would make a statement.
Yes.
Yeah, and that's what he somewhere in the testimony, and we see this with a lot of people have been exonerated as they feel guilt for falsely confessing, like it was their own fault. But I've talked to a lot of freed and exonerated people who feel so alone, like I'm the only who would do this until they're in a community of other people. So I think that's one powerful thing that he's doing by letting us tell his story.
Yeah.
Is for other people to realize that this can happen. The other powerful thing, especially with our listeners, and I want to give you a chance to speak to this as we wrap up, we've got a lot of law enforcement and a lot of private sector, a lot of investigators that are listening. So if you had to put on you're now the chief of detectives, or you're a sergeant, or you're in the training academy, what's some advice you'd give to investigators to do better?
I mean, I would.
a good question.
So, I
Record everything.
yeah. I mean,
Yeah.
I can't. It's hard to put yourself in the shoes of someone who's trying to do the right thing and try to figure out who did what and to try to protect society. And so, as someone who tries to be empathetic to my clients and whoever, I get the difficulty in that job. I feel like there are a lot of good folks out there who are just trying to get the information, and the results have nothing to do with what they're doing. But there's some folks who feel the pressure and will push and create awful environments and do all these tactics that we talked about. And it's hard to kind of like, I don't know, it's a hard thing to say to them, oh, don't do that. Because I get that you're trying to keep the world a safe place and all that kind of things. But like if you were able to just say, I'm going to try to just get the information. And if we could just live in a world where police officers were just like, I'm going to get the information regardless of what it says, and I'm going to move it on and let prosecutors decide what they want to do with it, I think we'd live in a better place.
I would say every interaction with a subject is a negotiation, and you are going to have a more effective negotiation if you use the tactics that we use with our clients who don't want to be honest with us when we first meet them. So in my initial meeting with clients immediately after they've been arrested, I never ask them what happened. I never ask, the sort of, I begin by giving them information. I say,
Right.
Here is what you are charged with, and here is what the police are saying happened. And over the course of my representation, we're going to talk about, what led us all to this point. But I don't begin by expecting immediate truth. I don't. And I begin by building a relationship. I begin by giving information. I begin by building a relationship and showing empathy, like Adam said. So I think you're going to have a more effective negotiation if you begin by building a relationship.
I want to just express what a tremendous honor and pleasure it was to work with you. And Legal Aid Society in general is just jam-packed with people who are so passionate about what they do. And to know that people who are in trouble have these resources is extremely well-educated, knowledgeable, and again, passionate people working for them. And I also want to thank the growing portion of law enforcement who are pushing very strenuously and consistently and relentlessly for change. And I think the solution can only be found through collaboration between scientists and practitioners. Because again, the scientific literature now has guidelines. We have evidence about what methods lead to bad outcomes and what methods lead to productive outcomes. So, and there are voices, a growing number of voices within law enforcement who are trying to inject the science into practice. So I want to thank all those fine people. And I want to plug Project Lethia, which is a center, air quotes, at John Jay College, where interrogation experts in the scientific domain and practitioners join forces to share best practices and attempt to bridge the gap between the science and the practice of interrogation. It's free to join, and there's tons of materials on our site about what you can do instead.
We will link that in the show notes too.
Thank you.
I'm a member, and it's a good mission and a good project to ensure collaboration. But I do want to thank you all really for sharing Thaddeus' story and your own. It's an emotional toll on everybody. It can be difficult to talk about, but the spirit of all of our episodes is, like I said multiple times, is on effective communication. And so for me, we've had takeaways not only on what happens in an interrogation room, how we can maybe fix that, but it was interesting to learn what does trial prep look like between the attorneys and the stress and the emotions. And I'm sure you seem like you all love each other and are really friendly here, but I'm sure there were some moments where you were ready to like go crazy with the stress and the emotion. So that communication is really neat to learn about. The communication with an expert, right? Preparation for trial and what you go through and kind of feedback and that. I mean, so just a lot of really good takeaways, I think, for listeners. So thank you guys for sharing your story.
Yeah, and thank you for pushing the needle on this, because you're just getting this out there and like having people hear. We want to make sure that this kind of stuff doesn't happen. And so your willingness to, your audience is primarily, law enforcement, and you're talking to a defense team about what happened in a case. So I think that's super important to hear.
Yeah, we appreciate you bringing us in.
Thank you all for listening to our two-part series of Innocent Until Proven Guilty. I again want to thank Adam Heyman, Anna Carlsen, Sarah Siegel, and Professor Maria Hartwig for offering their perspective and time and appearing on our show. I also want to thank the Brooklyn Podcasting Studio and Josh Wilcox for the AV support of our recording. And although we weren't able to have Thaddeus join us, we want to share our appreciation for his vulnerability in allowing us to share his story. Lastly, we want to recognize the first responders at FDNY that did such an incredible job in preventing any loss of life in this incident, and to the work that they do every day. Please rate our show and give us a follow so you can check out more episodes. And thank you all for listening to this series of Truth Be Told. Please make sure to like, share, and subscribe. And to keep this conversation going, follow the Truth Be Told podcast on LinkedIn and Truth Be Told CFI on Twitter. On behalf of the International Association of Interviewers, Rick Landers-Zalowski, and our valued sponsors, thank you for joining us on this episode of the Truth Be Told podcast.